Hello, everyone. I'm Ellen Babbitt, Senior Counsel in Husch Blackwell's Higher Education Group, and I'd like to welcome you to this webinar today. Before we begin, I'm going to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question and answer box. We'll try to answer all the questions during the webcast today, but if a fuller answer is needed or if we run out of time, we'll be answering this later via email. So a PDF of the presentation is going to be available in the program materials folder, and we also have a citation of authorities outline. We're not going to be talking a lot about cases today. We're going to be trying to keep it more practical, but we have those citations. There's a lot of cases since the pandemic, and these will be available in the program materials folder. So this program has been approved for legal education hours. For live attendees, please report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan our future programs that are applicable to your needs. Higher ed needs, business needs, whatever we're trying to do, we'd like to be responsive. So that's all for housekeeping items, and I'd like to get started with the program. So about the webinar, I want to introduce my co-presenter, Claire Hawley. Now, Claire brings an insider's insight to legal issues within the world of education. After her undergrad years, she earned a grant to work with the Illinois Network of Charter Schools. She worked with the legal team there. So we're really lucky to have her as a Husch Blackwell colleague. And I'm very lucky to have her as a co-presenter today. She brings excellent insights to these issues. So I'm an attorney. I guess I should say I'm an attorney also. I've been practicing in the world of higher ed, it turns out, for over 30 years. And so I've lived with you through a lot of these changes. It's my pleasure to talk with you today about an important topic, which is the issue of remote work as an ADA accommodation for those of us who work within higher education. So moving to our agenda is to refresh briefly on the purpose and relevant provisions of the ADA, which is always useful when you're talking about a specific aspect of the ADA, because it has several aspects. Today, we're talking about remote work as a reasonable accommodation under the ADA. And in that regard, it's important to review the state of the law pre-pandemic and post-pandemic legal developments, because obviously there's been a huge shift in the amount of remote work that was done since March 2020. Whether that shifts how the ADA analysis is done is the big question. And finally, we'll finish up with practical considerations and best practices, except I think we've changed it to good practices because we all aspire to the best. We'll start with the good and move to the best. So moving forward, first, let's do a brief refresher on the elements of reasonable accommodation. And so starting with first principles, what's the purpose of the ADA? Which, I think we all know, but we can all be reminded that the purpose is to ensure equal access to jobs, facilities, and services. It's a right to a level playing field, not to preferential treatment, which individuals can frequently forget, particularly students, and we have to remember. But the disability is a challenge because given the nature of the protected status, in some circumstances, the employer has to provide a reasonable accommodation in order to level that playing field. And what's reasonable varies from person to person and job to job. It depends upon the functional effects of the medical or mental condition upon the particular employee and the essential functions of the job. So as the saying goes, one person's diabetes is not the same as another. We have to look at the individual employee. We have to look at the individual job. So ADA was a landmark law passed in 1990 that built upon Section 504 of the Rehabilitation Act. And it has several prongs. First, we can't discriminate, no disparate treatment on the basis of disability. And that means we don't make assumptions based upon someone's medical condition or mental condition that they can or can't do a job. or they can and can't study at our institution. And I think we all know that. But everything is harder in practice than it is in theory. Second, no attributed discrimination. That's my phrase, but I think it works. We can't make decisions. We can't engage in disparate treatment based upon someone's history of disability, upon a perception of their having a disability, upon their relationship to someone who has a disability. And third, and this is our topic today, we do have an obligation to reasonably accommodate qualified employees with a disability in order to allow them to perform the essential functions of their position. That's our focus today. So, what are the critical concepts here? You can see a lot is embedded in there. First, what's a disability for purposes of the ADA? It's not necessarily the same as what's a disability for purposes of insurance policies or for purposes of K through 12 accommodation of students. Disability for purposes of the ADA, what is it? Second, what are the essential functions of a position? What does that mean in this context? And third, of course, what's a reasonable accommodation and how do we get there? All of these are central to evaluating whether an employee needs an accommodation and in particular, whether remote work, our focus today, is reasonable. So, what's a disability under the ADA? There's a statutory and regulatory definition of physical or mental impairment that substantially limits one or more of the major life activities of the employee. And many of us have heard this before, but reducing it to its essence, we're talking about any physiological or mental disorder or condition that's not temporary and that's serious enough to substantially limit a major life activity. Major life activity is defined very broadly under the ADA, and it's been expanded since the original ADA was passed. And the substantial limitation is also broad too. So I think, just summarizing this, since the 2008 ADA amendments, I think we should treat any non-temporary impairments, particularly diagnosed conditions, as meeting this threshold definition. The purpose of the 2008 amendments was to move us from granular consideration about whether a particular medical condition meets the threshold to a consideration of whether there's a reasonable accommodation. So many conditions will constitute disabilities under the ADA for purpose of triggering someone's right to a reasonable accommodation. So moving on, what's a reasonable accommodation? And that's our question today. Is remote work a reasonable accommodation? A reasonable accommodation is an adjustment or a modification to the work environment or to the manner or circumstances under which the work is performed that lets the person with a disability, the qualified person, perform the essential functions of the position. Now, a person does have to be basically qualified for the job. I, for instance, would not be entitled to a reasonable accommodation to do the work of a doctor because I'm not qualified to be a doctor. I don't have that level of training. I don't have those skills. But, I'm a lawyer, so I would be entitled, if I had a disability, to reasonable accommodations that would let me perform the essential functions. So what's an example of some of these reasonable accommodations? It can sometimes be job restructuring, sometimes reassignment to a vacant position, sometimes something as simple as getting an air cleaner in a room for a person who has chemical sensitivities or a humidifier, something like that. It can range from very simple to some profound and significant changes. But the important thing is what's reasonable for one person in one job may not be a reasonable accommodation for another person with the same medical or mental condition. It's very individualized. So, essential job function, another term I've just been bandying about, and we often do bandy about in the world of ADA compliance. Generally, an accommodation is reasonable if it effectively addresses the qualified person's disability while allowing them to perform their essential job functions. So what's an essential job function? It's not necessarily what we placed in the job description when we hired the person 25 years ago. It will tend to be what they actually do or what is essential to because of a limited number of employees, or what's essential because that's the reason the job exists. For instance, I think teaching is an essential function of a faculty member. Not as clear whether certain types of other work or administrative work would be, but teaching, that's the reason you hire a faculty member generally. That's an example. So, it will depend upon the particular job. So, the question is, how do we make sense of this? Moving on, and I'm saying moving on because I've asked Claire to move these slides so I don't mess up the platform here. Full disclosure. There are limitations here. Not everything is reasonable just because an employee wants to do it, or an employee's doctor wants him to do it, or just thinks that would be a great thing to do. There are limitations. For instance, if there's more than one reasonable accommodation that can address an employee's ability to meet essential functions, we do get to choose. The employer gets to choose between reasonable accommodations. Employees aren't entitled to their preferred accommodation, although we should always consider their preference. Employers also aren't required to provide an accommodation that causes undue hardship, and this is an enormously important concept. Undue hardship is an action requiring significant difficulty or expense. I'd say a change involving significant difficulty or expense. It can be financial or operational. Originally, when the ADA was passed, I think there was much more focus on financial hardship, and we often assume that that's what it means, but it's not just that. It could be a change, a kind of a fundamental change in the way a department is run, the way an office is run. It can be an issue of not being able to provide the proper service or the level of service to our student population, because after all, that's why we're doing this work. So there's much more than just the financial component here. I would say financial or operational, but whatever it is, we have to be prepared to demonstrate it. Here are some things that we're not required to do. Reassign an employee's essential functions. Occasionally we do that, but we don't have to. Make significant operational changes to the job. We don't have to create a new position for the employee. We don't have to hire additional employees to cover the accommodated employee's essential functions. These are examples of modifications that would not be reasonable, that would create undue hardship. So what does this mean? How do we get to this point? Because we have all these different concepts and we have all these steps that we apparently have to meet. And what we do is we engage in an interactive process. So yes, let's move to the interactive process, which is the unique but also absolutely necessary process that's going to be required, particularly, I'd say, when we're dealing with these remote work requests going forward. So now I'm going to turn this over to Claire for a few minutes to talk about the interactive process and also to take us through our first polling questions. Claire?
Hi, everyone. So now we're going to talk about the interactive process, which is a crucial part of ADA compliance that is often misunderstood. So as a baseline, to determine whether remote work is a reasonable accommodation, the employer and the employee must engage in this interactive process. The process is triggered by a request for an accommodation or by reason to believe that an accommodation is being requested. And it has to be an individualized assessment based on the employee's condition and their position. And the ADA and its regulations, unfortunately, do not contain precise guidelines on how an employer can show that it made a good faith effort to seek these accommodations. But the process is both involving a dialogue between the parties, and active, involving more than just assessing and deciding whether to accept the employee's proposed accommodation. So here is a little bit of a breakdown of the steps in the interactive process. This is an iterative cycle in which the parties work together, both proposing and responding to possible accommodations until hopefully a solution is reached. This begins when the employer is notified of an employee's disability. And as we mentioned, employees don't necessarily need to make a formal request or use magic words to trigger the employer's duty to engage in this process. However, that's how the process is most often initiated. In more uncommon circumstances, it can be triggered by a showing that the employee has a disability that may require an accommodation, even if they haven't necessarily overtly asked for one. So once that has happened, then the employer and the employee will meet and have a discussion. And most often the employee will kind of put forth their preferred accommodation. But the process is flexible, and courts will look to whether a reasonable employee would interpret the employer, a reasonable employer would interpret the employee's statement as a request. Then the employer responds. They may grant the request, they may propose an alternative, or they may request additional relevant information, such as medical documentation of the disability. Then they'll continue to negotiate until a reasonable accommodation is found, or in rare circumstances can't be found due to undue hardship. So the bottom line is that the employer's responsibility is to interact in good faith and consider alternatives. While employers don't need to accept the employee's preferred accommodation, they have to respond with alternatives that would allow the employee to perform their essential functions. When an employee requests a remote work accommodation for COVID-19, examples of alternatives that an employer might propose would be the use of personal protective equipment or PPE, social distancing within the office, or enhanced office sanitation procedures. The focus always remains whether something, even if it's not the employee's request, could permit equal access. And then there are 3 key principles, like things that employers should not do. So first, do not rebuff an employee's accommodation request or deliver ultimatums. When employers flatly refuse a request for an accommodation, they risk liability under the ADA. And merely because an employer states that in-person attendance is required, that doesn't mean that courts will necessarily accept that as true. So employers also should not rely on assumptions about the particular medical or mental condition, and they definitely should not be the party that cuts off interactions, if at all possible. This is because a party that fails to communicate during the interactive process may be acting in bad faith. And it's also important to bear in mind that employees are subject to this same duty of good faith to respond and participate in the interactive process. Okay, so now we're going to discuss the interactive process using 2 scenarios that are adapted from recent court cases. And before we tell you the outcome of each case, we'll do a poll to see what you think the outcome should be. So this is the first scenario. It's up on the screen. I'll also read it. A college professor requested to work remotely on medical advice due to a severe pulmonary disease. The university denied the professor's request and offered alternative accommodations, such as allowing the professor to teach in a larger classroom and requiring students to wear masks. The university also told the professor she could take paid FMLA leave if she preferred. The professor refused FMLA because that would have prevented her from using these previously approved research grants so that she could travel abroad to conferences in Paris and Rome. The professor also refused the large classroom and masks alternative. So the question here is, what do you guys think that the professor participated in the interactive process in good faith? And you should be able to select an answer. And once we get a critical mass of attendees answering, we can reveal how the court decided this case. Okay, we're at about 41%. I'll wait a little bit longer. Okay, we're at about 57%, so I'll go ahead and switch to the next slide. So most people said no, and you'd be correct. So this scenario is based on Dobbs-Weinstein versus Vanderbilt University, which was decided on March 22nd of 2022 by the District Court for the Middle District of Tennessee. So the court basically denied the plaintiff's request for a temporary restraining order allowing her to work remotely because it said that it could not reconcile the incongruity of the professor's request to be excluded from teaching in person with her plans to travel abroad. So the key takeaway is that one way that the parties, both either the employee or the employer, can violate the good faith requirement is by evidence showing that the accommodation request or offer is disingenuous. And if we were to consider a variation on this theme, the employer could have violated the good faith participation requirement in this scenario if they offered nothing in response to the employee's request to work remotely. Okay, so now we have a second scenario. Again, it's on the screen and I'll read it out loud. So in this situation, an employee had chronic back pain that made it difficult for him to access his office building. The employer permitted the employee to work remotely for half of the time. However, when the employee was unable to answer his supervisor's questions on an important project, the supervisor told the employee to return to work in person for all of the time. They engaged in a second interactive process, and based on that and updated medical documentation, the employer offered an alternative, which was a parking pass, allowing for quick and easy access to the building. The employee complained that this was not reasonable or in good faith, given the prior remote work accommodation. So the question here is whether the employer was obligated to continue offering that remote work accommodation. And we'll go ahead and open that poll. Some answers are trickling in here. There we go. I'll wait till we're about 50% we're at. There we go. Okay. Last call for answers, and I'm gonna switch to the next slide. Okay. So again, most people were right. The answer is no. And this case is based on Smith v. CSRA, which was a Fourth Circuit opinion that was issued in 2021. The key takeaway from this is that employers can revisit prior decisions to grant remote work accommodations as long as there are relevant changes in the underlying facts. So if an employee's essential duties or the nature of their disability change over time, then employers are free to reconsider that previous accommodation. So now we're going to turn to the current law regarding remote work as a reasonable accommodation. And first, we're going to start with pre-pandemic groundwork to kind of explain the approaches that were taken by federal agencies and courts prior to March 2020. So prior to COVID, generally in-person attendance was deemed essential by both federal agencies and courts. Key legal developments prior to that, there were EEOC guidances, three that were issued. The first was in 2002, and that was the first time the EEOC suggested that remote work could be a reasonable accommodation. Nevertheless, the EEOC's position was that employers are not obligated to create or maintain telework programs under the ADA. These guidances are kind of dated because they even use the word like telework, but we're basically talking about remote work. And then in 2003, they issued additional guidance with detailed instructions on how employers should determine whether a particular job could be performed remotely. And then in 2009, with the outbreak of H1N1 or swine flu, they issued additional guidance on pandemic preparedness and the ADA. So in that guidance, they described telework as both an effective infection control strategy and a reasonable accommodation under the ADA. They noted that employees with disabilities that put them at high risk for complications of pandemic influenza may request telework to reduce their chances of infection during a pandemic. And then also during this time, courts, even though the executive branch through the EEOC seemed to be warming up a little bit to the idea of remote work, courts during this time tended to reject arguments that remote work could be reasonable or anything less than an undue hardship. And often an individualized assessment was not required. So here are some examples of how courts dealt with this issue prior to COVID. In Tyndall v. National Education Center, the Fourth Circuit ruled that remote work was not a reasonable accommodation. And this case involved a professor who, at the beginning of the semester, he wanted to work remotely. And the court said, no, that's not reasonable because the beginning of the semester is a really critical time for students. So it's really important for their professor to be there in person. And this is important because it's also the only case in these pre-pandemic cases that comes close to making any kind of like individualized assessment specifically about like the job in question and what those demands were. And then in a really seminal case, Van Zandt versus Wisconsin Department of Administration, the Seventh Circuit rejected telework as a reasonable accommodation because in-person attendance was an essential function. The court stressed that individuals who work as part of a larger team need to be in person to facilitate collaboration. Van Zandt's also known for establishing a balancing test for determining what constitutes a reasonable accommodation. And that test is an accommodation must be efficacious to the individual and proportional in terms of a cost-benefit analysis. And then 2 years after Van Zandt, the Sixth Circuit adopted that standard in Smith v. Ameritech. They ruled that a phone book salesman's request to work from home due to a herniated disc was not reasonable because it would result in lower productivity in terms of his sales. Okay, so now, March 2020 was a time of sudden and unprecedented change. Almost everyone and everything was impacted in some way by COVID-19. So we're going to talk about what impact this had on the law and whether federal courts and agencies changed their approach to remote work. And in short, the answer is yes. COVID changed the legal landscape in a few key ways. Most importantly, some of the pre-pandemic assumptions may no longer be valid because they were disproven during the 2020 shutdown, as employers and employees adapted to remote work. So these assumptions that may no longer have as much strength are that technology can't support remote work, that technology for remote work is too costly, that employees will never be as productive working remotely as working in person, employees can never collaborate remotely, and supervision cannot work remotely. Many of these assumptions factored into those, especially Van Zandt and Smith v. Ameritech, those pre-pandemic court decisions that rejected remote work on the grounds of undue hardship. So let's start with the EEOC as how they've reacted to the pandemic. They've issued 2 guidance documents, a technical assistance document on March 14th of 2020 and an updated 2009 H1N1 guidance on March 19th of 2020. Both documents emphasize that employers can and should grant remote or hybrid work requests during the shutdown, and that employers have the flexibility to do so on a temporary basis as long as they establish end dates that are clearly communicated to employees. And since then, EEOC has filed 1 lawsuit on behalf of an employee whose request to work from home was denied. That case, which is pending still and is described in more detail on the next slide, it emphasized the continuing importance of the individualized assessment and of employers not just saying no flat out to requests to work from home. So in EEOC v. ISS Facility Services, the one filing, this was made on September 9th of 2021, and it was made on behalf of Ronisha Moncrief, an employee who worked at ISS Facility Services. She had a pulmonary condition that caused her to have difficulty breathing. And at the outset of the pandemic, the entire ISS facility shut down and all employees were required to work from home until June 2020. And then when the facility reopened, Moncrief asked if she could work remotely 2 days a week and then take frequent breaks when she was on site because of her condition. Her request was denied, even though at that same time, other ISS employees were allowed to continue working from home. And then soon after that, she was fired. And so the EEOC did not take that very lightly and decided to initiate enforcement actions against the employer. And this case is important. It's a pretty striking example of what not to do. It still remains pending in the U.S. District Court for the Northern District of Georgia. So turning away from the EEOC and looking back to courts to see how they've changed since the pandemic, they still seem generally reluctant to change their pre-pandemic approach to remote work, and some still even cite pre-pandemic case law for the proposition that in-person work is essential. They've also been unsympathetic to the argument that because employees succeeded in working remotely during the shutdown, remote work is now always a reasonable accommodation. Notably, of the 4 post-COVID reported cases that we've located involving educational institutions, all were decided in favor of those institutions. But now, while courts have not done a complete overhaul of the pre-pandemic approach, there is reason to think that they're going to scrutinize denials of remote work accommodation requests more closely. So technology barriers or excessive costs will no longer be a persuasive argument for not allowing an employee to go remote. And concerns about supervision or collaboration, those will vary within different campus functions. So the individualized assessment is really important because those will vary office to office and job to job. But saying everybody must return in person is not likely to satisfy an institution's burden of showing that it has made an individualized assessment. Arguably, that has never been enough, but post-COVID, it's definitely not. And in the 4 education decisions already mentioned, the institutions all engaged in an interactive process, and 3 of the 4 offered reasonable alternative accommodations to remote work.
Okay, I guess I'm off mute. I'm doing this right. Okay. Um, thank, thank you so much for that, Claire. And I would like to just stop right now and say we've gotten so many good questions here in the Q&A because this is extremely thought-provoking stuff. And we're all getting a lot of questions about this. Remote work requests from faculty, from students, from remote learning requests from students, remote work requests from staff in all sorts of different functions and offices. And so I was sitting here frantically trying to answer these questions while Claire was speaking, but I realized that what we should do is take all of these great questions and respond to them in writing and send it out to you all as a postscript to this webinar. And we've also had requests to speak about remote learning for students and accommodations for students at another webinar. And that's a great suggestion, which we'll take back to Husch Blackwell. But I definitely think that that's a subject of another webinar because we're getting these things in the context of student learning too. And faculty may have issues with having a hybrid classroom where some students are in the classroom and some are online. That's its own extreme challenge. So we'll respond to all of these questions separately. And that I think is the way to go on this because there are just so many good questions and it makes sense to continue this dialogue after the session. So now we're going to move to my favorite way of looking at these things, which is practically thinking about what's a good practice and how do you bring together all these concepts and work an interactive process. So, you know, you're interacting in good faith and making good decisions here. So these are some practical considerations and good practices for institutions answering remote work accommodation requests. And some of this does apply in the context of student accommodation, but you know the standards are a little different in the student context. So that the standards are for another day, but the process I think is sound, whatever requests you're getting. So moving to what I think is kind of a very nuts and bolts and important 30,000 foot point to make here is we have to have updated ADA policies. They have to be compliant and they have to work for us in 2022 to 2023, not 10 years ago. Things have changed. We've learned from the pandemic. We've learned from trial and error in trying to deal with the pandemic and these ADA and flex policies and all the different challenges we've had thrown at us. Let's update your institutional ADA policies and make sure they detail the procedures that are going to be used to evaluate accommodation requests, interact with medical providers, and interact with the employee themselves. And this isn't just make work for the HR and general counsel. We have to remember that people who are asking for accommodation requests have disabilities. Generally, they may be very upset because people can suddenly develop disabilities, develop serious illness. And the more we can communicate with them and in more appropriate detail, the better. I mean, the common way, wisdom is that when you're talking to someone who's upset or emotional, you want to deal with them. You want to communicate through multiple sensory channels, not just talking to them, but also writing it out. So we want to have updated policies that say what we do now, not what we did 10 years ago, and what we want to do. And this should include, I think, a full range of ADA-related policies. Even if these don't seem directly applicable to remote work, such as surface animal and emotional support animal policies, built-in accessibility policies. And this is all part of what we can offer and what we can talk about as alternatives when we have an interactive process. We have to make sure we have the full toolbox, so to speak. And our other policies are additional tools that we can use. And of course, and I will say, we have to make sure that our institution has actually complied with the nuts and bolts of Section 504 and the ADA. We have to have an identified Section 504 coordinator posted right there on the website. We have to provide appropriate grievance policies. I talked with an OCR person once, and I always, I generally admire the OCR. And they said, in very difficult situations, we know you have difficult situations on campus. We will work with you, but don't ask us to turn a blind eye if you're going to do things like not have a 504 coordinator, not have an appropriate policy. Do those nuts and bolts, comply with the easy stuff, and we'll work with you on the hard stuff. So I'd say update and apply ADA policies appropriately and make sure we've dealt with the nuts and bolts. So moving to our second best practice, we're going to actually move to our third polling question. And this is the flex versus ADA remote work policies, which I think is still a challenge for us. On May 15th of 2020, University X adopted a flex work policy, allowing employees to request remote or hybrid schedules. And this was in order to address concerns that they or family members were vulnerable to COVID-19 exposure. This is before any vaccinations, and we'll all remember that we either had formal flex policies or informal ones to address this. It was just humane. So faculty member Joe was granted the right to teach remotely during the fall of 2020. That's before any vaccination, and spring 2021 semesters, pursuant to this flex policy, which University X still had. He never claimed he was disabled and needed an accommodation. I think he said his wife was immunocompromised. Okay, so summer of 2021 comes, and University X informed the faculty that classes were going to resume in person. Everyone was very excited about this, or rather, half the population was excited and half of the population was not excited. Anyway, University X tightened up, but still offered its flex work policy option. So Joe wants to keep teaching remotely, and he now claims he has a disability. He never said this before. He says it now. He also reminds them that his wife is immunocompromised. So here's the poll question. Must University X consider granting Joe a remote work accommodation under its ADA policy, since it already granted him a year of remote work under the flex work policy? So if we can move to the poll. So that's the question. Yes, no, or I don't know. And we're open for, I think we're open for polling at this moment. So what do you think? Yes, no, or I don't know. Is University X obligated to consider granting him a remote work accommodation under its ADA policy, since he has already had a year?
We're at about 56% responded, so I can move forward whenever you want.
Okay, why don't we move forward? Okay. So most everyone, or a significant majority, said yes, we're obligated to consider this. 27.7% said no. 8.8% said I don't know. All of this is understandable because we are dealing with the situation that we would not have dealt with before the pandemic. But moving forward, I would say the answer on this one, I think, is you are always obligated to consider requests for an accommodation. Even if you've already given the employee a year's worth of remote work, and even if you think everybody needs to come back. So to move forward to the next slide, it's very important, and this is a best good practice that I find to be challenging, but it's absolutely the truth. We cannot conflate ADA rights with flex policies, which are in the nature, flex policies are not legal rights. If you have a policy, you have to apply it fairly, but you don't have to have that policy. And many institutions adopted flex work policies during the early pre-pandemic vaccination stages of the pandemic. And these are different from ADA accommodations, policies which reflect legal compliance obligations, not policy decisions. and the policy decisions we can rescind or change at will, as long as we do it in kind of a fair and transparent way. So it's very important to distinguish between flex requests and ADA rights. And while we're doing this, it's become increasingly challenging. We have to beware of the risk of discrimination claims. It should not be more difficult for an individual with a disability to justify remote work than for a non-disabled person to do so. In a sense, and in fact, I recommend that these be administered separately if you can possibly do it. A person with a disability submits documentation, engages in an interactive process, and if they're entitled to a reasonable accommodation, that's a legal right. And it may mean that they do remotely work for 6 months. It may mean that they get something else, but they have a right to that. A non-disabled person or a person who's disabled but reverts to asking for a right under flex policy doesn't have that right, except to the extent we've granted something under our policy. So we don't want to make it significantly harder for a disabled person to get something that a non-disabled person can fairly easily get. And this calls for some sensitive handling of this. And some institutions have revoked their flex policies. Some have turned this into a very rare occurrence that you would allow a flex, remote work modification or some level of it. We also want to be aware of retaliation claims. Disabled individuals who seek accommodations and the accommodation is denied shouldn't be penalized for having previously benefited from flex policies. And actually, that's more general. It's not even that it's denied. Someone who's disabled and got flex work under a general flex policy should not then be penalized later if they ask for something as an accommodation. So I'd say the answer to our poll was, yes, we must consider an accommodation request, even if someone got what we consider a benefit earlier under a flex policy. And this is a phenomenon we see when people take FMLA leave and then they come back and say, oh, I need an accommodation now. And everyone says, well, gee, they just got 3 months. Well, those are two different rights. Those are two different contexts. And we always have to consider an accommodation request. By the same token, though, they're not automatically entitled to continue working remotely because they had this option under a flex policy. Things have changed. We've reverted back to an ADA model, and you need to justify it, and you need to interact in good faith, employee and employer. But we're not going to penalize people for having benefited from our flex policies. And that's, I think, why the EEOC filed that suit that Claire was discussing earlier, because there was no attempt to interact, and there appears to have been no attempt to interact, and really, they basically seem to have been saying, look, everyone got to work remotely for a year, but that doesn't mean anyone gets to now. Well, maybe they do if they have a disability and it's a reasonable accommodation. So moving to our next good practice, and I know that one, the one we just talked about, bears more explanation. It's a big topic, but I would say beware of it, be careful about it, and make sure you keep your AD and flex policies separate. 3, here's another nuts and bolts that I'm not just doing this to make work for HR either. We need, if we're going to consider essential functions in an interactive process, we need to have updated job discriminations that actually talk about what people do, not what they were hired to do 25 years ago. And when we're talking about higher ed, we could very well be talking about someone who was hired 25 years ago. So it's really important to have some updated job descriptions. And I would say, I'm not trying to make work for HR, but this is a 5-star important thing to do for HR, at least for certain types of categories, probably faculty being the first one I think of. Many positions don't have updated job discriminations. You can use what you evaluate during annual evaluations as a way of getting at essential functions, but it's probably best to take your annual evaluation forms or templates and turn those into job descriptions, because it's really very important to be able to match the person's functional limitations and what they're requesting against the essential functions. So moving on, it's important to have employees present medical medical documentation, even if you feel like it's perfectly obvious that a person has a certain condition. If a person is very low vision or has deafness, you may say, okay, I know. You may know the diagnosis, but you don't necessarily understand, in fact, you don't understand the functional limitations of the particular condition for that particular person. And they really do vary. So medical documentation should usually be required. It should be properly verified, and it should be reasonably current. And it should describe, here's the wish list that will make all the ADA coordinators just hold their heads, but this is the wish list for what you'd like from the doctor. You'd like to know not only the condition, but the particular functional issues that are raised by the condition for that person. You want to know the expected duration as well, because as I adverted to this really briefly at the beginning, but we've been talking about this in the chat. Temporary conditions aren't actually disabilities that trigger the right to an accommodation. But, secondary problems that come from temporary conditions may be. So you want to know the expected duration of the disability or the need for an accommodation. You also would love for the doctor or treater to identify one or more reasonable accommodations and explain how they'll address these limitations. Now, of course, doctors don't have time for this, and they didn't before the pandemic, and they really don't now. So how can we help them? We can provide that job discrimination and say, how can the employee fulfill these essential functions, and what accommodations would help them do this? We can also ask specific questions of the treater, which tend to get better responses than just asking, can this person come back? So asking specific questions, providing some level of detail about what the essential functions of the job actually are, can really help tease out those specifics from a doctor. The employee should sign a release allowing follow-up, and the employee should actually seek the accommodation from the doctor, but the documentation from the doctor, but the documentation should go directly to you and not through the employee, if possible. And of course, these are aspirational. We do what we can, but this is probably the sound practice to get that documentation, review it, and then get into the interactive process. So moving forward to number 5 here, there aren't that many hard and fast rules in ADA compliance, as you can see, but I think one remains. We have to do an individualized assessment. Even if our leadership declares that the campus is back in person and they don't want to allow any remote work. And this is very understandable that everyone wants to get back, but it's never been the case that we could just declare we won't do X or we won't do Z when we're talking about ADA compliance. It's individualized. We almost never say never. So we need to do an individualized assessment in every situation in which an employee requests an accommodation. It may not be a big deal because they may ask for something that's really easy to grant, like an ergonomic chair or adjustable desk, something that we always grant. But we always want to do some level of assessment and documentation and ask for documentation from the doctor. But we can be flexible in what we accept depending upon the circumstances. And we want to be proactive in responding to requests and initiating the interactive process, even with repeat requesters or where a grant of remote work is unlikely. We want to do that. And the reason why I think I'll move to now is because, moving on, Claire, number 6 is we need to interact in good faith. We want to meet with the requester. We want to, one way or another, Zoom, call, in person. And we also have to meet with the supervisor and find out what works, what the essential functions are, what everyone else is doing in the department. Everyone on this call who's an ADA coordinator or focuses upon these requests knows this. We're doing an interaction that involves not just the requester and the ADA coordinator, but the supervisor. We want to ask questions, take and maintain notes, and follow up in writing with the requester, just because, as we said, people need multiple communications on these topics. And we do want to give due consideration for the employee's preference for a particular accommodation, even if we're pretty sure that we may not be able to grant it in this situation. Avoid assumptions. There has never been an area in which assumptions are more dangerous or more ill-advised. Now, when in doubt, if we don't understand why something's being asked, we can ask the employee for clarification. We can talk with the supervisor. We can ask to follow up with the treater. But we should treat this as a dialogue and an opportunity to make the best informed decision, because that's usually what it's going to yield the best informed decision. And it's also the risk management imperative that we interact, that we have a true dialogue, and that we work together with the requesting employee and the supervisor to come up with something that's reasonable, but it allows the person to perform the essential functions without working undue hardship upon that function. So moving on, speaking of which, you may find that what the person asked for, it just isn't reasonable. It isn't going to work. It's incredibly important to remember that our responsibility is there, even if remote work itself is not a reasonable option. We need to propose alternatives, such as, and there are all sorts of alternatives: hybrid work, flexible hours, a change in work location, a better parking spot, a job transfer sometimes. Some institutions can do that, many cannot, and other possibilities. We don't want to cut off the interactive process unless there really are no further alternatives to discuss. We want to be the ones proposing. So I always say you almost never want to be the one that says no without proposing an alternative. You can say, no, that's not going to work, but, and be prepared to document those attempts to seek reasonable resolution. And document means to the employee, not just internally. It's part of the dialogue, part of the interaction is that we continue to talk, even if what they initially want isn't something we're going to be able to do. So in that regard, and this is related, consider, I think it's an underused tool here, temporary accommodations or end dates. The EEOC has specifically said, and some of the courts, that we can provide temporary accommodations, see how they'll work, or end dates to these accommodations when we're not going to say, we're going to do it till then and we stop no matter what, but we're going to reevaluate at that time. We may need more documentation or whatever's appropriate under the circumstances. But temporary accommodations are often used in the context of student accommodations. Students are supposed to tell us what they want to do 3 months before they matriculate, but instead they show up on campus and they suddenly ask for an accommodation. Frequently, your student sides are granting temporary accommodations until they can get the documentation and figure out what's going on. We can do that too in the context of employment, and that is an underutilized tool. It can be used as a stopgap. It can also be used as a test period to see if remote work, the other accommodation that you grant, is going to be feasible. I definitely think that when you're talking about something that may be difficult to supervise or controversial like remote work, you'll want to place an end date on it for purposes of reassessing. Another thing to do is, and I know no one has time for this, but it's a very good tactic. It's a very good strategy. Tactic sounds too tactical. Strategy is to consider scheduling periodic check-in meetings with the employee and separately with the supervisor during any such temporary grant. It's a way to manage the accommodations rather than just let someone loose to work remotely for 4 months, say. So a related concept, which we've been talking about and we want to circle back to, is undue hardship. Remote work may work an undue hardship upon the institution for a number of reasons. And someone in the chat mentioned that it may be a problem for students. It may be a problem for students to have a faculty member teaching remotely. It may be a problem when students ask to participate remotely to have a hybrid workplace. There are things other than financial concerns that can constitute undue hardships, but we need to be prepared to discuss this, and frankly, we need to be prepared to justify this because undue hardship is our burden to show. and we can't just declaim it, that it's going to be too hard. But one thing that is really important to consider are the needs of the students. Some courses can't be taught remotely. So when faculty come and say, I want to teach voice and I want to do it remotely, that's very hard to do. Voices for music teachers, that's a good example. It's a quintessential class that, private lessons that requires in-person work. Sometimes it made it very hard during the first part of the pandemic because the teacher may be helping the student control their diaphragm and actually touching them where you can't touch them remotely. So sometimes some things cannot be taught remotely, and we will deny remote work to a faculty member in that situation. Sometimes we need a critical mass for certain types of classes. Some clinical classes have to be taught in person. And the essential functions of the particular position may not allow this. A campus safety person who has to walk around campus clearly cannot work remotely. A residence hall advisor can't work remotely if there are students in the residence hall. So there may be specific financial or operational requirements of the job. And another thing, though, and that we got something about this in the chat, I want to mention this, is prior experience supervising this employee remotely or this employee's job performance may, in appropriate situations, be a reason to deny or limit remote work. You have to be careful about this. You just don't want it coming out of nowhere. So it would have been good to document issues with the performance during a remote period. For instance, if someone worked during the shutdown remotely and they were terrible and you could never find them, that would be, and we have a record of that, that would be a reason to deny or limit remote work or say, okay, we'll try it for 1 month and see if it works. But supervisory issues with the particular employee can be a basis for denying or limiting remote work. But we have to be very careful about this because this is our burden. It can never be based on assumptions. It has to be evidence-based. It has to be something we can verify. Moving on, because I think we're almost at the point of finishing up, we always have to maintain confidentiality. The ADA has a separate confidentiality requirement, which I think probably everyone on this call, this webinar understands, but I just want to emphasize this. We share, even within the institution, only the minimum information needed to assess and provide accommodations, and that includes in the realm of remote work. Usually, supervisors don't need to know the specific diagnosis that the person has. They may not need to know the person's accommodation history in another job. We only share what they need to know. Faculty complain about this all the time because they want to know what's wrong with their students before they accommodate them. Don't get to do that. It's really a very much strict need-to-know basis. The other thing, and this will have people holding their heads because no one has time for this, we want to be as prompt as possible in responding to and resolving requests for accommodation and in managing an interactive process, because delays usually don't benefit the employer. And finally, I just want to close with one final good best practice. Everyone needs to remember that the obligation to accommodate is continuing. It doesn't just end after you grant an accommodation or deny it. Circumstances change. Medical conditions can change on a dime. Someone goes out, unfortunately, and gets hit by a car. I hope it's not anyone on this webinar, but it can happen to people. And suddenly a person who was fine is now very disabled. So we have to be prepared to be flexible and address things that we wouldn't have addressed or that we denied 6 months earlier. Remote work not being appropriate now doesn't mean that we won't have to consider it again in 6 months. We always have a new obligation to engage. And even if we deny the remote work as an accommodation, we just say it won't work in this job, we still have to talk about alternatives. Campus safety person can't be allowed to work remotely, but maybe they can have a hybrid schedule or be transferred to another job if something's open. We still have to interact, we still have to consider, and we have to be open to new accommodation requests. And I'd say this is the case even with positions that don't seem to lend themselves in remote work. And I just remind everyone that who knew in February 2020 how many positions actually could go remote 1 month later? We have to be flexible. We have to keep open minds, even as we're addressing this process very rigorously. So those are our best practice thoughts for today. We have a huge number of great questions that have been noted in the chat. And we're going to actually, what we'll do is we'll just respond to all of them, even the ones that I tried to respond to during the webinar while Claire was speaking. We'll respond to all of them subsequently, and we'll post that on the program page and send it out. I do want to thank you for joining us today. We hope this information was helpful to you and to your institution. And as a reminder, the program's been approved for legal education hours. To report your hours, just click on that CEU icon at the bottom of the screen. Second, we're going to send you a certificate of attendance, including course numbers, tomorrow with a recording of the webcast for watching and sharing. And please do complete our short survey. We use the feedback to plan more and better webinars. So this concludes our webinar. We thank you so much for attending and have a good afternoon. Thank you.